Hi, and welcome to the Red Wagon Estate Planning and Elder Law Show, hosted by me, yours truly, Jeffrey Bellomo. I would like to welcome you to the show today. And before we begin, just a reminder, please do not take any advice from this or any other radio show to constitute legal advice. If you would like to get legal advice and create an attorney-client relationship, please contact an attorney in your area where you live, in the state in which you live, to assist you. And make sure that they work specifically in the area that you are looking for. You want somebody very experienced in the area that you are looking for to give advice. But please do not take anything from this show to be legal advice. This is for informational and educational purposes only, and every decision is dependent on the state rules and state laws that apply. Well, awesome. Well, welcome to today's show. I am Jeff Bellomo, and on the Red Wagon Estate Planning and Elder Law Show, today what we are going to talk about is the dreaded conversation of, should I put my kid's name on the house? I have been thinking about what podcast I wanted to do for this week, and I received that question 12 times in 2 different presentations that I gave this week out in the community, and I decided, okay, we're going to specifically address this one topic and only this one topic on this podcast today. So first, let me begin by saying there's no doubt and no question that that's what you're hearing, that is what you're being told to do. That is what makes sense for people to do, right? And why? Well, on its face, it's easy. So it's very simple to prepare a deed, transfer the deed to your son or daughter, or both for $1, and be done. I mean, at the end of the day, that's about as easy as it gets, right? But the problem starts from that point, right? Because who owns it now? If you put the deed to your property into your son's name, who owns the deed? Who owns the property, right? Your son does, okay? Now, subject to your son's divorce, subject to your son's nursing home, subject to your son's car accident, to your son's death, right? What would happen if your son died? His estate would transfer to whoever his beneficiaries are, or whoever his heirs are, right? Well, that's probably his wife. So now you have the daughter-in-law owns the home, because your son is deceased, and now are they going to let you live in your house? Well, it's their house actually, but are they going to let you live in their house? Is she going to let you live in their house for free? Yeah, maybe. Yeah, right. Let's give the benefit of the doubt to the daughter-in-law. Let's give a shout out to the daughter-in-laws out there. Yeah, maybe. All right, now let's fast forward 10 years. She's now remarried. She has a husband. Maybe they have a kid or two of their own. How is the new husband going to feel about the ex-in-law living in their house that they own free of charge, or living there at all, right? Ooh, maybe not quite as well as we originally thought, right? Maybe not as well as we had hoped. You always have the issue of the divorce, right? I cannot tell you how many times in my 20-year career that I have seen people who received an inheritance, take the inheritance, pay off the mortgage on the marital property, and then within 6 months there's a divorce. And they split everything 50-50, and voila, the daughter-in-law or son-in-law ended up taking some of the money that was completely intended to stay in the family as part of the divorce. Or where the deed goes in the name, or the assets go in the name of the son or daughter, they end up having a stroke. They end up in the nursing home. Well, whose assets are they at that point, right? At that point, they are assets of the son or daughter of their nursing home. And you can't just gift the money back, right? There's a 5-year look-back period. If those of you who've been listening to the podcast, you know that there's a 5-year look-back period on transfers for Medicaid purposes. So it's not as though we can just cure it, right? We can't just transfer it back and say, oh, look, here it's back in their name. Because if the son or daughter needs nursing home care, they have a 5-year look-back period to worry about. And the one case that I think about often, it was a Medicaid case years ago. It was back, I don't know, let's say 15 years ago. And the mother transferred everything to the daughter. And they came in to meet with me, and the daughter had a stroke. Okay, so essentially now all of the assets that came from mom are now assets of the daughter, and the family wanted to know what we could do to help, and we certainly put a plan together for them. But fully realizing now that all of those assets that were mom's are now daughters, so artificially inflating what daughter actually owns, right? His daughter didn't technically own those, but she did because they were transferred to her. So we did our thing, and we essentially, argued that half is what would count. Half of the assets would count. Why? Well, because mom owned half and daughter owned half. Well, lo and behold, the caseworker takes the position that the day before the stroke, how much could the mother have taken out of the account? Or vice versa, how much could the daughter have taken out of the account? And the answer is 100%, right? We know that the daughter owned the assets. She could have taken out 100%. We know that the mother could have taken out 100%. Either one of them. So the caseworker took the position that, therefore, 100% would count against the daughter. Now, I wasn't happy with it, but we still have a lot of great planning techniques that are available. We were still able to get a great result for that family. They were happy. Everybody was happy. Life was good. Well, then a few years ago, guess who ended up having her own issues and ending up needing the nursing home? The mother. All right, so now we got a problem because we've already counted 100% of the assets for the daughter, and we were able to do a plan that was able to protect them for her family. But as far as I'm concerned, when I go into a pizza shop, right, and I eat the pizza, the whole pizza, it's gone, right? There's nothing left. Maybe crumbs if you're lucky. Well, I think very similarly. So when I filed the Medicaid application for the mother, the position I took was, you've already received the pizza. You've already eaten the pizza, right? The pie is gone. You can't get it anymore. It's just crumbs left. And the caseworker called and said, why did you omit those assets from the mother? And I said, because you already counted them. You already received them. You already had them in your first initial case with the daughter, and therefore the pizza is gone. And she laughed, and she thought that was cute. And she said, well, in every Medicaid case, I get to evaluate the facts and circumstances with that specific case, regardless of any other case. And in this case, the mother transferred assets within a 5-year period. Therefore, the mother is going to have a penalty. Therefore, the mother's going to have a problem. And of course, I kind of joked and said, oh, spare me. You're going to use the argument of the day before the stroke. How much could the mother have taken out of the account? And she said, oh, no. I already used that one. Who contributed the money to the account initially? Whose money was it? Well, it was mom's, right? Yeah. So they brought that back in 100% for mom, for assets. And, it was a rigmarole, and it was certainly not a lot of fun in my opinion. But it's also something very telling, right? And very warning. And just people do things for reasons that they believe are going to be the right ones, or they believe it's going to turn out the way that they expect it to, right? And so my point of these podcasts and my point of being out in the community on a regular basis is bad things happen to good people, right? Bad things happen to good people. So just because we expect a circumstance to turn out a certain way does not mean that it will. Either something happens to that person, they change, they're in a divorce, they're in a car accident, they're in a stroke, they died, right? Whatever. Those are things outside of our control. So what I like to do when I'm doing planning is I like to do things that are in our control, that are within our control, so that we control the outcome, right? That's why I do not like the outright transfer. I do not like the whole putting your kid's name on the deed, right? That is just not something that I like. Why? Because I lose control. In 2010, for those of you who have been fans of ours since 2010, at that time we were at 910 South George Street in York, Pennsylvania, and it was a building, and you had to go behind the building and take 3 steps to get in. And I just loved that charm of that initial building that we were in. Certainly nothing like the one we're in today, but for our first office, I was quite proud of it. And I vividly remember a friend of mine coming in with his mother and sitting at the conference room table in that office. And they had read somewhere about putting the son's name on the deed. And, I asked to meet with the mother alone, even though the friend was the son. It didn't matter, right? My client was the mother. So I met with the mother alone, and I explained, I do not like this. I do not think it's a good idea. But I trust him completely. He would never hurt me. And I said, well, not intentionally. And I agree with that. I don't believe he'd ever intentionally hurt you. He's a friend of mine. But that doesn't mean that he couldn't go through a divorce or be in a car accident or die or have a stroke and end up needing long-term care or you name it, right? And the mother kind of looked at me for a little bit and she thought about it. And ultimately, she did not listen to me. Ultimately, she went ahead and did what she wanted to do. And I did. I read the riot act a little bit to the son, kind of made sure that I made my point very clear. Look, don't plan to do anything with this. There's a 5-year look back period. Your mom could need it back if she ends up needing long-term care in the next 5 years. So make sure that you keep, the assets safe, that you keep it unencumbered. And, I'm kind of telling him everything. And it was about a week later that I got the call from the mother that the son kicked her out of the house. He put an eviction notice on the door and started the landlord proceedings to remove her as a landlord-tenant issue with the district magistrate. And ultimately, mom was out of a house. And who owned the house, right? The son did. And I to this day cannot believe that individual did that. And to this day, I cannot believe that occurred to someone that I know and that I read the riot act to. But the truth is, you don't know everything that's going on, right? You don't know everything that's going on behind the scenes. And he had, what I would constitute as a crazy daughter-in-law, right? Or his wife was crazy. So the variable in that situation that we can't predict was the daughter, right? So she wasn't in the room that day. She wasn't there. But at home, what was going on behind the scenes, right? She was in his ear. She was chirping away, right? She didn't like the mother. She didn't care for her at all. So she took the opportunity the minute that it was in his name to do exactly what she wanted, which was get rid of her, right? Remove her, evict her from the house. So it was horrible. To this day, that is one of the cases that I think back on. Now, I will admit, it has happened at least 5 to 6 other times in my 20-year career where people evict the mom, the dad, right? Every case is different. Every case had a different reason. Every case had a different excuse. And no, none of them were recommended by me. None of them were something that I recommended to do or that I suggested we should do. In fact, in all of them, I begged and pleaded to not do it. But the truth is, they read about it on the internet. Their friends told them about it. Their advisor told them about it. The accountant told them about it. And that is the reason why at Bellomo and Associates, we do weekly workshops in estate planning, in crisis Medicaid planning, in special needs planning, probate and trust administration planning. We believe in education first and foremost, so that you are educated and understand the implications of what it is that you're doing before it happens, right? Before the stroke happens, before the question pops up at a holiday about transferring assets to your kids, right? It's also why we created specifically in the estate planning context the 3 lands to protect your family's security, right? We discuss in the 3 lands that there's tax land, there's long-term care land, and there's estate planning land. And all 3 of those lands have distinct purposes. They have distinct purpose as far as what they're going to do, how they're going to do it, and what are the rules for each land. And in the workshop, we go into each land, tax land. Here's all of the tax rules you need to know. Long-term care land. Here's all the long-term care Medicaid issues you need to know. And then here's all the estate planning rules. Here's what estate planning is. And at the end of the day, the point of that exercise of the 3 lands is to show that for every decision you make, there's going to be an equal and opposite reaction in another land when you go there. It's just like physics, right? In physics, for every action, there's an equal and opposite reaction. In estate planning, for every decision, there's an equal and opposite decision that's going to occur in another land. So simply because you're allowed to transfer something tax-free in tax land does not mean that you won't have an issue in long-term care land. We mentioned a couple times, what's the look-back period when it deals with Medicaid, right? It's a 5-year look-back, which means if you put the deed to the house in someone's name, it better be 5 years before you need long-term care, right? And I'm going to do you one better. If you say it's jointly owned property, right, you're going to put a joint owner on it, the problem there is now the caseworker can always look back and see who contributed the money to the account. So you think you're doing yourself a favor. You think you're protecting yourself by leaving your name on it, and actually you're hurting yourself more than you would have had you done it the other way, right? That's completely counterintuitive. It doesn't make any sense. I know. But when it's joint owned, they can look back as many years as it's been jointly owned, 20 years, and see who contributed the money to the account. Mom did. All right. Well, then 100% is going to count against mom, right? So that's not what we want. That is not the outcome we were looking for. That is not what we expected. And then we walk to estate planning land and we say, okay, well, what is estate planning? I want to control my property while I'm alive and well, right? Control is the key thing there. Well, if you give it away, or if you put someone's name on it as a joint owner, how much do you control it? You don't. Even the joint owner can take out 100% without you knowing. And if they own 100%, certainly they can take out 100%. Certainly they can do an eviction notice and remove you. Now, people don't like to talk about that. And I know what you're thinking right now, listening to this. You don't know my family. You don't know my son. You don't know my daughter. You know what? You might be right. I don't. But I knew that one. I knew the other one. I knew a third one. And I knew them really well. They were friends of mine. I'd done dinner with their families. There is no way you would have convinced me back then that they would have done that. No way. I was worried about the death, the car accident, the nursing home. I wasn't necessarily worried one bit about the son or daughter hurting the mom or dad. Never. Not even a possibility. But again, things happen behind the scenes. Things happen in the home, right? That daughter-in-law, and particularly in that one case, we had no idea that's who she was. We had no idea that she had ulterior motives. But people do. So you have to assume that. So, okay, Jeff, you've made it very clear that you don't believe that the outright gift to the son or daughter is a great idea. No, I don't. I absolutely do not. So what's your alternative, Jeff? Well, for those of you who have listened to our podcast, if you've ever been to a workshop, you know that we teach trusts through the use of a radio flyer red wagon, right? So I just happen to have one here today. And for the longtime users of our podcast, you know that it usually sits right here over my left shoulder, right? It's our visual. It's how we teach trusts. It's the simplest way that we can come up with to teach trust to get people to understand it, right? When you were a kid, what did you keep near and dear to you? What did you keep close to you? Well, G.I. Joe figures, Barbie dolls, rocks, whatever it was that was important. The wagon is the concept. It's the same thing. As we get older, what do we keep close to us, right? What are the things that we want closest to us? Our house, our investment accounts, that place at the cabin, right? Maybe that place at the beach. These boxes represent an asset that you own. And all we do is we change the deed from Jeff Bellomo and Whitney Bellomo to Jeff Bellomo and Whitney Bellomo, trustees of the Bellomo Family Trust, right? So now what do we know? We know the trust, the Bellomo Family Trust, owns the property, and that Jeff and Whitney are the grantors because they created it. They're the trustees because they're in control of it. And they also have a right to live in it, right? So they get some benefit from it as well during their lifetime. It's a win-win-win. Now, because I control it during my lifetime, when I die, it is going to be included for inheritance tax purposes. That's a good thing. That's a good thing. I know you immediately went to that's a bad thing. It's a good thing. Why? The rate for lineal descendants is 4.5%. But once the lineal descendant receives the property and the 4.5% inheritance tax is paid, we get a step up in basis. So now if the child sells the property, they don't have to worry about paying capital gains tax at a rate of maybe 23.8%, right? So it's a huge benefit. You actually want it to be included. And I know, again, that's counterintuitive. But the advantage of the trust is that if the son or daughter has the stroke or the death or the nursing home or the crazy daughter-in-law, you don't lose anything because it's in the trust. It's not owned by the son or daughter. It's owned by the trust. Even if mom doesn't make it through the 5-year look-back period, we still have options. We still have ways to get at the assets if we needed them. And it doesn't hurt anybody, right? So now you've got the best of all worlds. You've got the asset fully asset protected. You have it included for inheritance tax purposes, which means you get the step up in basis for the kids, and the property cannot be lost once we get outside of the 5-year look-back period to nursing homes. It is a wonderful solution. Yes, there is a fee to do the trust, certainly, but nursing home costs currently in New York are about $13,000 a month. The average in the state of Pennsylvania is $14,000. These trusts cost less than 1 month nursing home cost, and you're able then to protect the assets for the rest of your life. So it is certainly something that is worth it. It eliminates the risk. It eliminates the concerns. It eliminates bad things happening to good people. All right. I hope you enjoyed the podcast today. I know I certainly had a lot of fun. This is probably my favorite topic to talk about. Why? Because I've seen it go wrong so many times, and it is so painful to watch. It's so, painful. It's just rough. It's you could have avoided it. You didn't because you wanted to save a few dollars, and at the end of the day, you ended up losing everything. That is really difficult to watch, and it's also hard not to feel terrible and to feel some part of it as well. And that I will not do anymore moving forward. We are definitely getting the word out there that there are much easier ways to accomplish the same objective with zero risk or very little risk. So let's talk about the trust. Let's talk about protecting assets and not just throwing someone's name on the deed or someone's name on the account. And if you listen to the whole podcast today, you know that I'm even less intrigued with joint ownership than I am with, the outright transfer. So seek counsel, get representation, somebody who understands all of this and can advise you on the implications of it. But as a general rule, what's my rule? Don't put your kids' names on the property. You love them way too much, all right? Thank you for joining us on the Red Wagon Estate Planning Show. I am Jeff Bellomo. It was truly a pleasure spending this time with you today, and I look forward to the next time. See you real soon.